Good afternoon, everyone. Hi there. Sorry I'm a little bit late. Thank you for joining today's webinar, Record Keeping for Associations. Thank you for joining us today. My name is Millie Ventura, Business Development Manager for the Palm Beach region here at Castle Group, and I'm joined today by Allison Hertz, Shareholder Board Certified Specialist in Condominium and Plan Development Law at Becker. Please note this webinar is approved for one HOA rec credit for both CAMs and HOA board members. This course does not provide condo board credit. On the screen, you'll see instructions on how to submit questions via the chat. Please hold all questions until the end. We will be monitoring the chat, and I'll allow time at the end to answer all your questions. I'm going to turn it over to Allison now to introduce herself and get us kicked off.
Hi, Millie. Hi, everyone out there. Thank you so much for joining us today. Thank you for Castle for having me. I'm Allison Hertz. For those of you who don't know me, I'm a shareholder in Becker's West Palm Beach office, part of our South Florida team. I'm sure you know Becker. We have offices all over the state of Florida, here in South Florida, West Palm, Fort Lauderdale, Miami, Stewart, up a little bit north, Orlando, West Coast. I won't go on and on. But I'm very happy to be here today to speak with you about official records issues. And if you've been in the industry for a long time, or if you're new to being a board member or a manager or work with us in, association issues, records issues are always constant. They've always been constant. They are very time consuming and they can be frustrating quite often. So I hope I can provide you with some suggestions today. I know I will, and some good resources and information to help you with records access issues. Records have evolved over the past couple years. I mean, we've always had the obligation to maintain records in condos and homeowners associations and provide access to members who request the access. But over the past, let's say, 5 years, the laws have really changed and evolved. And it's probably because of that word we hear all the time dealing with associations is transparency, right? So when the legislature hears from its constituents that they feel they have not been provided with access to records, they don't know what's going on in the association, the legislature acts, and we see a bunch of new laws year after year related to official records. So it's really sort of changed in terms of requirements, access, websites. We've seen so many changes over the past couple of years. Another thing we've seen a lot of change in the past few years is unit owner, lot owner empowerment to get access to records through enhanced DBPR jurisdiction. We've seen a surge of DBPR complaints made over failure to provide access to records, and the DBPR does investigate those, which behooves all of you, board members and the managers, to really try your best here to deal with records. One of the kind of scary things we've seen over the years is criminal penalties for records violations. It's kind of crazy to me that this is the one area where you could be, perhaps prosecuted for failing to provide access to records. It does have to be willfully and knowingly. And I've not seen this used yet. And don't be too scared about this because, I've never seen it. I don't know about you, Millie, but, this is not coming up all the time, but it is there in the statute, which is kind of crazy. AI, right? Like we all love AI and use AI. But AI, I've seen as an association counsel used, much frequently for records requests. And these records requests are sometimes, incorrect, right? So don't always believe AI. I mean, I know people want to dig in their heels and think that, it has to be correct, but frankly, it's not correct a lot of the time. So with all of this said, uh, there are admittedly difficulties with records maintenance and records access, and I wish there would be some reform in this area in terms of the law because it is very time consuming and, like I said, very frustrating. I see and believe in the need for owners to have access to records. That's extremely important. It is open records for the most part in an association, but we do unfortunately see the habitual records requesters who, use it as a tool to harass the board and management, and it can become very difficult. But don't make the records access maintenance your full-time job. There are things that you can do to help yourself, help, use management to help you to not get completely bogged down by these records requests. So we'll go through just a little bit of the basics first. I'm obviously in the Florida Condominium Act and the Florida HOA Act, there are a lot of records listed as required records that you have to keep. Like these are the records of the association that are part of its official records. Like obviously you have your governing documents, your meeting minutes, your contracts, financial statements. As of the past couple of years, there's been a push to further define what type of financial records the association has to keep as part of its official records, what owners are entitled to access. And that's fair enough. I mean, if you're a paying owner in a community, you should be able to see how your money is being spent. Insurance policies, statements of account for each owner. So there's, and I'm not going to go through like verbatim of the statute. I think we can talk about other more interesting things. And, with the help of AI and a search tool, like you can find what the particular official records are that need to be kept for your condo or for your HOA. I will say, typically speaking, the retention period for these records is 7 years for most of the records. Bids and voting materials are going to be 1 year retention, and milestone inspections and structural integrity reserve studies have now a 15-year required retention period. So, there are the direct, expressly specified records in the statute that are part of the association's official records. But then it has like this default catch-all phrase in both the HOA and Condo Act that all other written records of the association not specifically included in the list, which are related to the operation of the association, are part of the association's official record. So it's kind of like all records of the association,
Mhm.
like all documents, right? I mean, it's
It sounds
there are
crazy.
limits. There are limits, which I will talk about, but it's kind of like open records. That's how I describe it. So, quickly, just in the event, the Condo Act was amended a couple of years ago to provide that to address like records that are lost or destroyed or otherwise unavailable, right? Because frequently, like I see associations go from management company to switch management companies, and unfortunately, they have not been able to keep all of the records. Or get all of them transmitted. Obviously, you have boards that change over the years. If you don't have management, you're even in a worse situation with trying to make sure that you have all of the records for the past 7 years. So, what is the obligation there? The Condo Act says that in the event records are lost, destroyed, or otherwise unavailable, that you have an obligation, a good faith obligation to attempt to obtain and recover those records as reasonably possible. So I think that basically means that you have to make an attempt to try to get the records that are required to be kept as part of your official records. If you write that former management company a letter and they like refuse to provide access to the records, listen, you wrote a letter, you have the letter in the file, you've made a reasonable good faith attempt to recover the lost records. If you write to the former board members who you believe had these things within their homes or units and they have not turned them over, I think personally that that's like a good faith attempt to try to get the records. So uh, a lot of a lot lately, frequently, we receive requests from owners looking for records, mainly like emails between board members or emails between the manager and the board or text messages or WhatsApp messages, which I really don't recommend, by the way. But this has become, an area where people try to like to poke at this area, right? And this is not expressly addressed in the Florida law, by the way. There's been a few arbitration cases at the DBPR, and there's a declaratory statement up at the DBPR. By the way, the declaratory statements are only binding on the parties to the declaratory statement. That is not like binding law. And arbitration cases, frankly, are, used in arbitration, but they're certainly not binding in like a court of law, by the way. So the gist of this here, based on, everything that we have to use as guidance, and the position that I usually take is that communications between a board and management are part of the official records of the association. Like that's the association's agent, and that's part of the records that perhaps are accessible to members and their representatives. What about board to board communication, right? If your association has established an official, email address system, like you use Allison Hertz at ABC Condo and everybody on your board uses abccondo.com as their email address, there is guidance that those official email communications are part of the official records of the association that are accessible by members. There is a distinction, however, when board members are using their personal email addresses. So if you're using your old AOL account or your Gmail and you're communicating with each other, I think the position that is correct is those are not part of the official records of the association. The association doesn't have access to that. That's personal emails of board members. And it's the same thing on like text messages. I suppose if your manager has a phone that the association is paying for, and that's the association's property, perhaps those text messages are part of the records. That's not generally the case at anymore where, everyone has their own phone. But typically speaking, unless there's some kind of association paid for phone, text messages would not be part of the association's records. While there is that requirement to try to get records that may be otherwise unavailable, that means that they were actually part of the association official records. That doesn't mean you're a detective now and you go track down records that aren't even part of the association's records.
So do you recommend, Allison, that the board establish an email address for association related, information so that they can maintain a personal one separately?
Well, I think that's probably the better approach as we go into the future. I think we've been so caught up with like not allowing certain records to be accessed and, saying, oh, that's not part of the association's records, but like drawing a line in the sand and having what I have recommended to clients before is a communication policy for the board that basically says like you have to use your official association email account for official board communication is probably the way that we need to move in the future because it does what I said, draw a line in the sand between personal activity versus board activity. I think it also promotes professionalism, whereas if this email is accessible, that you're going to conduct yourself in an email as you should as a board member, perhaps. And which I will touch on later, sometimes the association is involved in litigation where you need to get access to these emails upon in discovery, like court ordered, access, which is completely different than the records access we're talking about here. And to have the official emails available in the event of litigation and you really need to get this information, it could be important. I mean, since we're on the topic, text messages are probably not the way you want to communicate as a board. That's not, you can't access it at a later time. And while I understand it's convenient for a lot of purposes, it's probably not the way you want to move forward in association communication. So I think this is an area that we will see develop in the future, in the near future, as people start thinking about these issues. Like, okay, let's actually look at this a different way by saying, this is an area where we can actually have some black and white and not a gray area, because nobody likes gray areas,
Mhm.
right? Like that's just complicated and sometimes expensive. So I do agree that having the official email, uh, you know what to expect. Everyone likes to understand what is expected of them and what will happen. And if you know those emails are subject to inspection, so be it. So, okay, let's move on. We'll talk about what is not accessible to owners. And again, I'm not going to go through like the statute verbatim here, but personal identifying information of owners, not accessible. I mean, that's kind of a no-brainer. Social security numbers, emergency contact information, driver's license information. Information obtained by an association in connection with the approval of a lease, sale, or other transfer. So, like applications, right? If you approve transfers and somebody completes a very detailed application form, that is not subject to access by other members. Medical records, I'm like, why would we have medical records? But as many of you know, like sometimes there's requests for accommodations to accommodate somebody with a disability. We need to have some level of backup in terms of reviewing and approving these accommodation requests. So medical records are a no. Personnel, these are sort of okay, those are kind of like the easy no-brainer ones, right?
Mhm.
Everyone can
Yeah.
kind of understand those and okay, we can accept that. Now we get into like a little bit more of the difficult ones, which are the personnel records of the association and management company personnel. So if you have, disciplinary reports or reviews of personnel, payroll, these are not accessible by members of the association. Very important to me, attorney-client privileged or work product privileged confidential communications from the counsel for the association. We get this all the time that somebody wants to access an opinion that I wrote about, filling a vacancy, we'll just say. My confidential advice is not accessible to the membership at large. And that's important to protect the association, and particularly when you're in litigation and there are, sort of high stakes issues going on and money on the table. So I figured I would do like a rapid fire top five common misperceptions about records, accessible, inaccessible, right? Okay, so we're gonna go from like we'll do the countdown. So number five, I get this is misperceptions. Manager employment contracts or management contracts. Okay, so I just told you personnel records are not accessible by unit owners, but there's always like an exception and then an exception to the exception. So the exception to the exception is that your contract with your manager employee and certainly your management company contract is open, it is accessible. That is not a personnel record that can be excluded from access. So that's number five. Number four, oh, this is a biggie, email addresses. I want to get all of the email addresses of everybody in the community because I want to send out email blasts, probably leading up to the election, right? Or perhaps regarding some project that I think is not appropriate or is going to be too costly. So I want to get access to all of
Oh,
the
they're having
email.
an event. They're having an event, so we'll make it fun.
Oh, okay. Or okay. I like this. I always get the bad things. So Millie says they're having an event and they want to
Yes.
invite all of their friends. Like, I'm going to use that actually because that is actually a nice one. So, are owners entitled to other owners' email addresses? And the answer is it depends. It depends. If you have asked owners to consent to receive official notices by email in lieu of getting them by mail, the email address used for that purpose, the email notice purpose, is accessible to other owners. If you've not asked owners to consent to email notice instead of getting it by mail, then emails are not accessible. It happens all the time where, like, perhaps the association has email addresses that they just use as a courtesy, but not as a substitute for official notice purposes. In that instance, the email addresses are not accessible. So it's only in that one very particular narrow instance where the email addresses become accessible when it is used for the official notice purpose of the association. Okay, number three on our countdown is attorney-client privilege documents. I've already did go over this, but it is so important to me. I doubled it up here because I do receive, and you probably have seen this too, very frequently an owner will, say, I want the letter from Allison about X, or all
Mhm.
documents from Becker relating to the dispute I'm having with the association. No, you don't get to have inside information or, inside trading. You don't get to have all of our advice to the association about the dispute you're having with the association. So that's a no. And it's very important to know, if you do these records inspections yourselves, that that is excluded from access. Like, don't give them the legal file, okay? And if they're specific questions about, maybe, they've asked for invoices from the attorney, right? I mean, yeah, they can have invoices from the attorney, but sometimes you'll have to redact certain attorney-client privileged information. So that's an area where you definitely want to get your attorney involved if you have owners who start asking for, legal information. Okay, number two on the list is video surveillance. Owners asking for video surveillance. Like, I want to see the video from, Tuesday night between 9 and 10, because, I try to think of something good as you suggested, but I don't really, know of anything good of why somebody would want a video.
Yeah,
Yeah,
that's kind of
no.
hard.
I mean, listen, it's sometimes for what I would think is a legitimate purpose, where their car was vandalized, or some damage was caused to something on their property. But in my opinion, video surveillance is not part of the official records. It's not on the list. It's not a written record in the catch-all, or there's nothing telling me that it is. There's no case that says it is. And I think it's a security issue at a certain point where, I don't know why you would need to have access to the video surveillance. And if you really need access, like, you can get it through court action. So that comes up all the time, and my position is no. Then the number one misperception about records that I've received throughout my entire legal career, which I've been representing associations for my entire legal career, 20 years now, is the AR list, the delinquency list, right?
Mm.
So the owner, wants to see the AR list because, presumably they want to know, like, what the financial health is for the association. So the manager or the board doesn't think that that's appropriate because it's a privacy issue, but that's not correct. It's actually a part of the records list that you have a statement of account for each owner showing what the balance is, and that is subject to inspection by other owners. It is not something that you use to post on the elevator, where there's, like, now called a deadbeat list. But if somebody actually asks for it, you are required to provide access to. So that is sort of like my number one misperception I see, like, year after year after year.
Can
Anything
you
else?
clarify something on that, Allison? Because,
Yeah.
so in the past, what I used to do was I would just provide the unit number, but not the owner's name, right? So is that something that is good practice, or you just give it with everything in it?
I think you give, if somebody asks for it in a written records request, right? You give it in its not, and you give all the information, right? But I think when you're in a board meeting and you're talking about delinquencies, like to the members in attendance at the meeting, I surely think that it's fair and perhaps more sensitive to use the unit number rather than, Mrs. Jones when you're perhaps having the board authorize foreclosure, right? Or, suspension of use rights because of a delinquency. So I think in that case, unit number is just fine. But if somebody asks for, makes the request for like the full report, you give the full report. Yeah. So again, that's like the number one thing I see year after year after year. So I think I think many of us know that owners are entitled to get this access, but don't forget that their authorized representatives are also entitled to access records. So if I'm an owner, I can designate my sister to access the records or my attorney, right? And in a condo, renters actually have the right to get access to limited things like the rules and I believe like the structural integrity reserve study, but renters actually have access to like very few things in a condo. Just put that to the side. Um, so obviously it's owners, their representatives you're required to provide the access within 10 business days. And sometimes I people confuse this and they think that you're required to get back to these people within 10 business days. Like, no, you answered them promptly and try to set some kind of access up, whether it's a physical inspection, you direct them to the website, you say you're going to email them the records or provide them with like a link to Dropbox where they can obtain the records, but the actual access has to be provided in the 10 business day period, not 10 regular days, 10 business days from receipt of the request. So you receive the request today, the first day begins tomorrow, and then you have 10 business days. The condo law was amended recently to say that records have to be kept in an organized manner that facilitates inspection by owners because like I think many of us have been involved in records inspections either as a board member, manager, lawyer, unit owner, where you're thrown in a room with like 50 boxes and it's like go fish. So they did amend the condo law to say it had to be kept in an organized manner that facilitates inspection. Like, what does that mean? Lawyers can argue what they want as to what that means. I think best practices, labels, folders, physical files, and then if you're going to have it online, some header of what the category of the record is. So what do you do when you get like one of these burdensome requests that we do have to deal with, right? I mean, if
Yeah, that was going to be my next. Yes, exactly. You get this really broad one where there's no timeline, there's no specific thing that they're asking for, and you could send like you said, I have a whole box of things I could send you because they weren't specific enough with their request.
yeah, so well, I'll tell you what the arbitration cases say is like if it doesn't make a lot of sense or if it's like overly broad, you can comply by making all of the official records available for inspection. But like, listen, I said at the beginning, you don't want to make this your full-time job. And
Right.
sometimes you do feel like you want to make it difficult for the person making the request because they're either made a lot of requests or they made it very, burdensome for you. But, when you think about it, if you're going to make it difficult for them, a lot of the times you're going to make it difficult for yourself. And it's like, at the end of the day, just if you're if you're the manager, you're the board member, you're the attorney having to deal with this, oftentimes you got to just be above and take the high road and frankly do what's best for yourself. You only have so many hours in the day, so I'd rather make it easy for myself by providing perhaps a link to the records than making somebody come into my office and inspect face to face. That is available. That is a tool that can be used in certain instances, and it is appropriate to be used in certain instances. This is kind of like a case by case situation sometimes. But back to the burdensome request, oftentimes when I get these, I ask the requester to narrow it down. And I say, listen, I got your request. This is a voluminous number of records. It's probably not going to be helpful for you, for me to even give you this many records. Like, what are you really looking for? I mean, kind of common sense in terms of just communicate with the person who's making the request and say, is there any way that you would be willing to narrow down this request? Right? And I'd say 9 times out of 10, they say yes. So that's like the first thing I would suggest. When the
Mhm.
request is not clear, where they don't give dates. I mean, sometimes they don't even realize that it's that unclear and that, oh, well, okay, like I guess, they just copy the entire statute. Like, are you really looking for 7 years of these records, or is there some shorter time frame? We want to make sure that you get the information that you're looking for. Try to be helpful. Sometimes being nice actually gets you something with these type of requests. So again, I think 9 times out of 10, if you ask them to narrow it down into like, what are you really looking for here? What time periods are you looking for? We're not clear about, X, Y, and Z. Can you please provide some clarification? You will receive a response, and generally it's going to help you make this process less painful. Sometimes you'll receive a response and they'll say, no, I'm not narrowing it down and I want everything. And like, so be it. You'll have to deal with that. But that is it more infrequent than having somebody narrow it down. Okay, so another like quick fire suggestions about records access. And I'm just going to go for the number one suggestion here is have a rule. And have a rule that you understand and that you can comply with. I see a lot of these rules that are like 30 pages for a records access rule. And like, you got to be able to work within the confines of your own rule. Like, if you can't comply with your own rule, what's the sense of having a rule? So have a rule about, you know, how records requests need to be made, where they perhaps will occur, when the association will send the link versus when the association won't send the link, how many requests can be made within the month, right? In my opinion, the two best rules that you would have in this rule package are, I'm one that would probably recommend records request access by email. I know a lot of attorneys say that it has to be by certified mail, because it makes it more difficult. But like, why are we making it difficult for people to like get records, right? I mean, people want the information. That's why people get upset. That's why the laws are so stringent, because records apparently haven't been provided. So listen, can you have a rule that requires a records request to be made by certified mail? Yes, you certainly can. And in a homeowners association, the penalties don't even kick in unless the owner sends it by certified mail. So there is that aspect to the HOA statute that is not in the condo statute. But if you're going to allow records access by email, that you would want to require the person to include in the subject line of the email, the RE line, that this is a records request, something of that nature, records access request, records request, because what happens sometimes is we all get so many emails. Like, I get so many emails, Millie, I'm sure you get, and managers, you get a lot of emails, and boards get a lot of emails. Like, I'm shocked. So you'll have an email from somebody, they'll be making a bunch of complaints, and you'll somewhat get sick of reading it. And then at the end of the email that's already this long, they'll make a request for access to official records, and you could miss it. And you could miss it.
Mhm.
So I think having the rule that the subject line must contain records request is one of my top rules. Who the records request must be sent to. That's another thing, because does it have to go like we just presume it's like, well, it goes to the manager, right? It goes to the manager. Like if I get it as a board member, I can just ignore it. That's actually not true because if you don't have a policy, uh, if you then anybody on the board who gets the records request is deemed to have, started that 10 business day clock. And this is particularly important due to that criminal penalty issue that I talked about at the beginning. So in your records policy, you would have a stipulation that records requests sent by email must be sent to this email address, a designated email address, or the manager, or some specific person. And that person is responsible for monitoring their emails, obviously, and acting appropriately once the request comes in. The third most important rule, in my opinion, would be to limit the number of requests on a monthly basis. And listen, I feel like at a lot of associations, this is not a big deal. That you don't really get a whole lot of these harassing records requests, but at the other associations, which typically goes more to legal, right? And maybe why some of you are even on this webinar is that it becomes so overly burdensome to have to deal with this that having the written policy limiting the request to perhaps no more than 2 to 3 a month, the case laws sort of like, or arbitration cases are all over the place. You could have reasonable rules regarding the frequency of records requests. So like what's reasonable? What's reasonable to me is different than what's reasonable to a judge, right? But I mean, perhaps 2 to 3, it depends how aggressive you want to be, and it depends really like how big of a problem this is to you. But having that in a rule is very important. Another thing I'll mention is like we're asked to prepare these rules all the time, and we do, and we give it to the boards. Make sure you actually adopt it at a board meeting. Don't have us prepare this rule for you and then not even go forward with scheduling the board meeting. So put this on the agenda for your board meeting, consideration of records request rule and adopt it and send it out to the owners and put it on your website and in the line of, top five, I don't know where we're at in the suggestions at this point, but be uniform in administering your rule. Like I think it's very unfair to have this rule and only apply it to like one person or two people or whatever. So if you're gonna have the rule, realize that you do have to administer it uniformly across the board to all of the owners. So when you're thinking about the rule, think about that. Like, are you making it too strict? Because you're going to have to apply it uniformly. Um, Lastly, before we get into websites, I do talk a lot and I know we want to take questions. I just wanted to mention one other thing about official records generally that, a lot of the requests that we receive are like, I want a list and a chart and a spreadsheet of like all of this compilated information that is not really part of your records. Like you might have documents that you could use to create this chart or list or spreadsheet that the owner is asking for. But you as a board, you as a manager, you don't have to create records that don't exist. This comes up all the time. Like I want a chart of, no, you get the source documents. And if you as the owner want to prepare a chart or a comparison or whatever, you can prepare that on your own. We will give you the source documents that are part of our official records, which you could use to create the chart. And I wanted to make sure I said that because this comes up all the time and it does drive people crazy and they go about creating records that don't exist. And once again, this is not your full-time job to deal with records requests. Like there's managers spend an inordinate amount of time dealing with this when there are so many other things going on at the property that need attention as well. So don't don't get caught up in creating records that don't even exist.
And I just want to mention before you move on to webinars, Allison, so you're getting an email. Obviously, you're going to respond via email, so there's proof that you've responded. But if you're having someone come to your office to inspect the records because they handed you a paper and they want to come to the office, get a piece of paper with, the information that they requested and have them sign off that you provided the information because you want proof that you did respond and they did come to inspect.
That's a really good point, and it leads me to the checklist requirement. So similarly, at least for a condo, you're required to simultaneously provide a checklist to the person who requested the records, um, which basically creates a presumption that you complied with the request. So the checklist is kind of what Millie is referring to. The checklist is, there's no form, there's no really detail as like what this checklist is, but it's a checklist of records that were provided and not provided. I think those who use AI think the checklist is like what's known as a privilege log in litigation, and that it has to be this like very detailed report of like why you didn't provide certain records, or the reasons, and like all this other detailed information. That is not correct. I don't know why AI keeps spouting out that information, because it is not correct. But it is the fact that you have to provide a checklist for a condo, and maybe you just do it for an HOA, even though it's not required to provide that receipt that Millie is suggesting, because that is important. Boards change, managers change, and there could be a claim at a later time that the association didn't comply, and to have that sort of receipt or acknowledgement document could be important. So switching a little bit to websites now, both condos and HOAs now have website requirements. This is well known at this point. Condos with 25 units or more had the website requirement go live January 1 of this year. That is a lot. I mean, there are small condos, but I'd say the majority, if not more, 70-80% of associations are under the website requirement, condos at least. HOAs, 100 parcels or more had the requirement to have the website go live January 1. This is where like management becomes critical, because it's it's like people think this is easy, and in practicality, like just getting the website rolled out is one thing, but actually maintaining the website is kind of the more difficult aspect, I would think. So, having management available to maintain your website is a good tool. If you don't have management, I think a designated person on the board, whether it's going to be the secretary or you have a committee assisting with this, but definitely think about it and formalize it, perhaps at a board meeting where you have, in the minutes that this person is sort of responsible for dealing with the website. So, that's the go-to person. There's
Yeah,
a
Allison, in prior years, we used to have quarterly audits to make sure that there was website compliance, but this has gotten so cumbersome, and there's so much that it's required that now Castle employs we have a full-time compliance department that monitors the website
wow.
monthly because there's so much that could get missed, so you want to make sure you're in compliance. Yeah.
Well, that is huge. So that is like a amazing tool to have, not only like the manager maintaining the website, but also the backup auditing of the website, on an ongoing basis, because we do see owners, complain that things are stale or things haven't been uploaded. And it's interesting because we've been seeing more and more requests by the DBPR, at least for condo. They don't deal with HOA investigations, for access to associations' websites to actually investigate compliance. So the DBPR will write a letter saying that, they're investigating a complaint about failure to maintain the website properly. Like they want access to the website, and you are required to give them access to the website to follow through with their investigation. Um,
And
so,
there's fines associated for not maintaining your website. We were discussing this just
oh,
yesterday.
yeah, the fines can be pretty significant for condominiums. They're like up there, and they don't really like give a whole lot of warnings like they used to. So, listen, the legislature, the citizens of Florida have sort of like spoken as to, bad associations, We all know a few can like ruin everything, and
Right.
they want to show that they're doing something about it. So there's so much more investigation and fining, and that's a shame. And that's why like trying to do your best to comply with all of this. We're talking condo really now because DBPR does not have jurisdiction over homeowners associations for investigation of records access issues, but uh, it's part of why this is important. Part of why. I mean, first and foremost, in my opinion, is to just like make sure the members are able to get the records that are appropriate and that they should be deserving to see where usually it's where their money is going.
Mhm.
So there is a list in both the Condo Act and the HOA Act of the records that have to be kept on the website. I won't go through that in detail because we are under time constraints. But I will say specifically the latest and greatest for condo is the video conference meetings that we know now if you're going to have a Zoom meeting, a Teams meeting, a hybrid meeting for your condo association, you're required to record it and you have to post it on the website. And the website must include, the preceding 12 months of association recorded meetings. Um, we always used to say like, well, when are you supposed to put this stuff on the website? Like, is it like the next day? Is it 6 months? Like, and I would always say, it's a reasonable amount of time because there was nothing in the law that stated when records had to go live on the website. The Condo Act has now been changed to say that you have 30 days from when the record was created to get it on the website. So condo, we do have a specific requirement now, which is the 30 days. For HOA, we don't have anything specified. I suspect that HOA law will catch up with condo
Yeah.
law in terms of video conferencing and these like little detailed requirements. But perhaps you use the 30 days as a benchmark for HOA anyway, because apparently that's what the legislature thought was reasonable. And perhaps you use that, although there is no black and white requirement for you to post within 30 days. Um, and before we go to questions, I just wanted to mention one last thing, and I touched on this earlier on, is like, what if you're in litigation? Like, what if you get like one of these letters from, a personal injury attorney or any attorney that's a demand to preserve evidence? That's something that you definitely want to remember because you are required to preserve, protect, not write over, not throw away, not discard records if you get a demand to preserve evidence. So you put a hold on those records. Obviously, you're going to talk to your lawyer about this, but you will receive those demands to preserve evidence from time to time, usually on the outset of perhaps a lawsuit being filed, right? And then when you're in litigation in court, there are going to be times when there is court issued discovery, which you will have to produce records like outside of the confines of this. So I just did want to touch on that. So we kind of like knew some of the distinctions and to particularly mention that preservation of evidence because if you get one of those and then you throw the records away, you could be, I guess I would say, in trouble, sort of. Like it could be a problem at a later time. That's how I'll put it. So I've talked a lot and probably pretty quickly. And I think we have some questions. Let me see if we can get to those. I don't know if I have access to the questions. Oh, here they
It's
are.
at the bottom under Q&A.
Yeah. Okay, so let's see. I'm gonna go to the end because okay, so Gina says, I thought HOAs are not required to record their board meetings. You're correct. You're correct that the video conference recording requirement is only for condos, but perhaps we will see that as a requirement for homeowners associations in the future. And, maybe you just record them and put them on your website anyway to make sure people are informed about association business. That's really like a board business judgment decision. So that's at whatever your board sort of wants to do in that regard. Let's see, Daniel, can we charge residents for the cost of providing the requested information? This is a good question, and I get this all the time. And the answer to this is generally no. The law does, that's like the problem with the law in a lot of ways, where you're spending so much time, or your management company is spending time to obtain the documents and filter through documents where you're not allowed to charge them for the cost of access. You can charge for the cost of copies if they come into the office to get copies. And in the HOA law, it does provide that you can charge administrative time for the cost of making the copies. It's not really for the cost of actually like retrieving the records that somebody just looks at and takes a picture of with their phone. So I really am glad you brought this up, and I feel that the laws definitely need to evolve in this area. Like, listen, it's a very fine line because owners are entitled to the information. I don't you think you can charge them a lot of information, even if the laws
Mhm.
changed. Like, I don't see the law allowing an association to charge. And the answer to this is put the stuff on the website, right? If most of the information is on the website and you can just direct somebody to the website or in a link, it just becomes so much easier. Although I know there are instances where the records being requested are just like not the nature that they're going to be on the website. And that's when it does become more difficult and it is very frustrating. Oh, Barry, my friend, let's see. Doesn't section 718, 19, and 20 require the requested official records to be provided within the 10 business days? So that merely providing the dates to inspect after the 10 business days is a violation. Yes, we went over this. So basically, you have 10 business days to provide access to the records. That, you don't respond to them in 10 business days and say that the access could be provided 2 weeks later. That is not what the statute says. So Barry, you're correct as usual that the access needs to be provided in the 10 business day period. Sometimes the owner is not going to be able to like you suggest a date because you want a physical inspection, and that doesn't work for the owner. So you have to work together to find a mutually agreeable time to have make this happen and not make it so difficult for the person that it's unable to be accomplished. Um, Let me see. Anything that you're seeing that you think is Louisa says, are we required to release data electronically, i.e. membership data on a thumb drive? No, you're not required to release data electronically. If you want the requester to come to the association office to inspect hard copy records or sit them in front of a computer and they can scroll through the records and identify the records that they want to print at their cost, that is an option, but you certainly are not required to provide them with electronic copies of any record. Sometimes it's easier, but I understand for various reasons that people don't want to do that. Okay,
Vanessa has a question about if a unit owner requests meeting minutes about a certain topic, am I required to find the minutes for them, or can I just refer them to the building website and have them search for the minutes they want?
good question, good question. So in the condo world, we are confident that you can direct them to the website because it says that black and white in the statute that you can comply with a records request by directing them to the website. And, if your website's set up in sort of like a complicated way, perhaps you give them a little bit more detail as to like under which tab they want to search. I don't know if that's required, but I think it would be nice and it doesn't take that much effort usually. And then you don't have to hear from this person again. They get the records that they want. And at HOA, there's nothing that exactly says that you can direct them to the website, but I think generally it can be workable that you do so, but you might want to engage with your counsel on that one because it doesn't have the exact same language as the Condo Act does in terms of directing them to the website. All right, I'm going up. So this is a difficult question, but I'm going to answer it. Jackie, it was regarding my comments on owners not being entitled to attorney-client privileged information. And Jackie Grant says, but if owners suspect rogue boards are not quoting attorney correctly regarding an issue, what can be done if I can't see the actual legal opinion? I mean, honestly, that becomes like a political issue at a certain point where like get these people off the board. If you don't think that they're acting appropriately or you're suspicious or you want to be entitled to receive or review attorney-client privileged information, you got to get on the board. There's just no other way of dealing with it. It's just not going to be possible due to the constraints on attorney-client privilege. Like I should, the board should be entitled to get counsel. I should be entitled to give counsel in a confidential manner. And um, that sort of becomes a political issue a lot of the time. That's how I see it. Employee contract with management is available. Please clarify, and employee contract with the association, is it available? Well, the answer to that is the management company contract is always available. I don't know if you have a management company or you have direct employees. Some employees don't have a contract. I mean, oftentimes you're going to have, if you don't have a management company, if you employ your own employees, every employee is not going to have a contract. But in the event you have a manager and the manager has a contract with the association, that contract is accessible by owners. Let's see. Why is WhatsApp not recommended? That goes back to the communication policies that I was recommending, because when you're dealing, I wouldn't say conducting, but when you're dealing with official board business, you know, in order to protect the board and the association, the communications may need to be accessed at a later time. And WhatsApp, somebody's personal WhatsApp account is probably not going to be able to be accessed at a later time should they need the information. And it's just not, professional to communicate on WhatsApp. And I think the wave of the future is trying to have these more professional communication protocols so everyone once again like knows what's expected, what to expect, who can receive copies of their communications and who cannot, and distinguishing between your board communications and your personal communications. And Millie,
Allison, I know
yeah.
we've run out of time, unfortunately, but I wanted to share your information on the screen in case someone wants to get a hold of you. They have your contact information. And thank you, everyone, for joining us. Obviously, we love that you join these webinars and you're keeping yourself informed. The webinar will also be uploaded on our website if you want to refer back to the content or you want to share it with a board member or a property manager. Again, thank you all for joining us. Allison, thank you for your time. We truly appreciate you.
Thank you so much. Thank you. Thanks for everyone. And thank you to Castle.